Police officers have options when you arrest a person. In some cases, a police officer may make a custodial arrest. However, if you are arrested for a domestic violence charge, you usually receive a summons. If the police suspect that you have committed a serious crime, they will arrest you and place you in jail. This is called a custodial arrest. You'll be handcuffed and transported to the police station. There, they will book you, obtain your information, take your mugshot, and take your fingerprints. And they might try to question you about the suspected crime. After a custodial arrest, the police will hold you in jail until you can post bail, or if you can't post bail, you'll be transported to court for the arraignment. That's your first court appearance. If you are released on bail, the police will give you a court date. In every domestic violence case, the court date will be the day following the arrest, and an automatic protective order will be put in place even if you are released. This means that you cannot have any contact with the complainant, and you cannot return home, even if you share a home with that person. Police officers can have options when they arrest a person. You may face a custodial arrest or simply a summons. If you are not released on bail, the police will hold you in jail until the next date the courts are open. The police will then put you in the back of a car and transfer you to court for the arraignment. The judge then reviews bail, and he or she will enter a protective order for the case. A typical domestic violence case involves custodial arrest. The police have to separate the people involved in the argument, and Connecticut law requires protective orders that prohibit contact between the parties until modified by a court. A custodial arrest is a very serious legal matter. If you or a family member are subjected to a custodial arrest, you have legal rights, and you should speak with a lawyer about legal representation immediately. We can reach out to the police, advise them to stop talking to you or your loved one, and be present and help them get out of police custody. The police do not have to take everyone that is arrested to jail. When police arrest someone for a lesser misdemeanor, typically motor vehicle crimes like reckless driving or like breach of peace or threatening, the police can arrest you by summons. This means that the police officer will arrest you, but instead of handcuffing you and bringing you to jail, the police officer will hand you a piece of paper with the criminal charges and the court date listed. You are ordered to appear in court on the date listed on the summons. If you fail to appear, then you will be ordered rearrested by the judge. And then you are charged with the additional criminal charge of failure to appear, and that subjects you to a custodial arrest. A summons is very different and far more serious than an infraction ticket. Those tickets are issued by police for offenses that are not crimes, like creating a public disturbance or a parking ticket, and can be paid without appearing in court. A summons is an arrest for a criminal charge. If you are arrested by summons, you should immediately speak with a lawyer about legal representation. If you know someone who needs this information, please share it with them. If you have more questions, please contact us. We are here to help.